Appeal, Welsh Ministers and PJ.
Ms Richards, before we begin, may I just remind everybody that the court has made an anonymity order in this case, in the usual form, which I understand is agreed between the parties, that no one shall publish or reveal the name or address of the appellant, who is the subject of these proceedings, or publish or reveal any information which will be likely to lead to the identification of the appellant or of any member of his family in connection with these proceedings. I always remind people of that at the beginning of these hearings because we are, of course, live streamed and slips are easily made. Thank you.
My ladies and my lords, this is, as the court knows, the appellant's appeal from the Court of Appeal's decision, the effect of which we say was to hold that a responsible clinician has the power to specify conditions in a CTO, the practical effect of which would be to deprive the community patient subject to the CTO of their liberty in the community. That this power arises, said the Court of Appeal, notwithstanding the absence of any express statutory provision to that effect, that the patient cannot complain of or challenge the deprivation of liberty before the first-tier tribunal or mental health review tribunal for Wales, and that the only means of challenge would be judicial review. We will be submitting, for the reasons set out in the written case, which I will amplify, that the Court of Appeal was wrong so to conclude, and will be addressing further two additional arguments raised by the respondent, one raised rather late in the day. The court has, I hope, Mr Gordon's note or supplemental submission filed on Thursday with an additional bundle of materials. We have filed a response to that this morning. I'm afraid we couldn't do it any quicker. I'm not proposing to take up the court's time unless the court wants to, with arguing about whether or not the arguments should be heard.
Well, it's a very fundamental point. It does mean that Mr Gordon will be riding two completely inconsistent horses, but then that is not uncommon in this court.
And that's his concern rather than mine.
Yes.
So, my lady, we're content on the basis set out in our note for the court to consider the arguments. We're conscious that this court will want to consider all available arguments and reach the right answer. We do simply ask, because we've responded to the material that Mr Gordon has filed, we've not had the opportunity to do any further significant research of our own. We do ask that we have the opportunity so to do. It may be that there's nothing further that we want to put before the court.
Well, we'll see where we are at the end of the day.
Thank you, my lady. So the way in which I propose to structure my submissions is as follows: to take you first to the statutory provisions governing community treatment orders in the Mental Health Act. Secondly, to deal with some aspects of the factual background, not, I hope, in great detail, but there are a small number of documents, the risk mitigation plans and the CTO itself I want to take the court to. Then, thirdly, to deal with the statutory power necessary implication argument, the principal reasoning of the Court of Appeal. Fourthly, to deal with the question of the tribunal's jurisdiction, and then to deal with Mr Gordon's two arguments. His first, that the test for deprivation of liberty in this context is not the Cheshire West acid test, but rests on a comparison between pre-CTO and CTO circumstances, and then finally his new point. So if I can invite the court to take up volume 1 of the authorities bundle and turn to tab 1, MS, page 470. The court will have there the material provisions of the Mental Health Act. My ladies, my lords, I'm conscious, of course, that at least, I think, 4 members of this court recently heard the arguments in MM, and there is obviously a significant overlap, albeit different issues arise. I'm going to be focusing, obviously, on the CTO provisions rather than the Mental Health Act more generally.
We did look at the CTO provisions when we were dealing with conditional discharge, but obviously they are different.
So I'll just start very briefly then with section 3 on page 470, MS 470. Simply to make the point that what we see there is Parliament providing an express power to detain a patient and to do so for specified purposes according to particular criteria in a hospital.
Oh, it goes further than that, Ms Richards. If you go to section, I think it's section 6, isn't it?
Yes, MS 472. We then have the effect of that admission and their specific authority, both for conveyance in section 6, subsection 1, and then specific authority for detention in subsection 2. And then if the court turns on, please, briefly to section 17, leave of absence, which is MS page 480. The court will see there the power to grant leave of absence vested in the responsible clinician in section 17, subsection 1. And then in subsection 3, I simply draw attention to the fact that the responsible clinician can specifically direct that the patient remains in custody. So again, there Parliament is expressly addressing the custodial position, if I can put it that way, of the patient who is given leave of absence under section 17. And then we get to the CTO regime in section 17A onwards, MS 483. Section 17A is the power to make the community treatment order. Subsection 17A1, clinician may by order in writing discharge a patient from hospital subject to his being liable to recall. And then we have the criteria for the making of the community treatment order in section 17A, subsection 5, and various other provisions. I don't propose to dwell on the precise content of section 17A. What I do ask you to do is turn to section 17B. And this is the provision that deals with conditions, and this is the statutory provision which the Court of Appeal held, provided by necessary implication the authority for community detention. Section 17B1, a CTO shall specify conditions to which the patient is to be subject while the order remains in force. I emphasise those latter words because of Mr. Gordon's new argument. Subsection 2 sets out the basis upon which conditions may be specified, agreement of the approved mental health professional required, but the touchstone for the responsible clinician is that the conditions are necessary or appropriate for one or more of the following purposes. And the court will see there set out 3 discrete purposes: medical treatment, preventing risk of harm, protecting other persons. So those are the general words, the general power in section 17B2, which the Court of Appeal held was sufficient to authorise deprivation of liberty in the community. We then have in subsection 3 what we have described, and indeed what various official materials describe as the mandatory conditions. So those are the conditions which have to be included in the CTO. In contrast with section 17B2, which provides an enormous amount of discretion vested in the responsible clinician as to what conditions to impose. Subsection 4 is the power to vary conditions from time to time. No particular procedural requirements there, nor any requirement for the agreement of the approved mental health professional. Subsection 5, suspension of conditions. And then subsection 6 says this: if a community patient fails to comply with a condition specified in the CTO by virtue of subsection 2 above, so there again we have the language of the patient being expected to comply with the conditions, that fact may be taken into account for the purposes of exercising the power of recall. And then subsection 7, nothing restricts the exercise of that power to cases where there is such a failure. So we accept, of course, and the Act makes clear, that breach of a condition does not automatically or necessarily lead to the patient's recall to hospital. But it is clearly provided that it may be a factor which will trigger the responsible clinician's power to recall the patient to hospital and thus render the patient, again, liable to be detained in hospital. Turning then over the page to section 17C, you have the provisions for the duration of the community treatment order. Those have to be read with section 20A, which I'll come to in a moment. And then if the court turns over to MS 490, section 17D, you will see there the effect of a CTO is that the authority of the managers to detain him under section 6.2 is suspended. That's section 17D, subsection 2A. And then at B, reference, however expressed, in this or any other act or in any subordinate legislation to patients liable to be detained or detained under this act shall not include him. And we say that is clearly identifying on the part of Parliament in this provision that at the point at which the patient becomes a community patient, any authority to detain him is suspended, and any reference in this or any other act to being detained or liable to be detained no longer applies to him. We say those are express words that are, at the very least, a pointer away from the construction favoured by the Court of Appeal. And
that's a distinction between these patients and conditionally discharged restricted patients who do remain liable to be detained.
It is. And then section 17E, MS 492, is the power to recall to hospital. And section 17E set out the primary criteria for recall, requiring medical treatment in hospital, and risk of harm to the health or safety of the patient if not recalled. And then subsection 2 provides that the RC may also recall a community patient to hospital if the patient fails to comply with the conditions specified under section 17B3 above. So those are the mandatory conditions, making the patient, basically making him or herself available for examination. Again, we have the language of failure to comply, and that in and of itself can be sufficient for recall to hospital. And then we see in subsection 6, we then have the recall notice then provides the authority for detention. So again, Parliament is expressly addressing in the explicit language of the Act the point in time at which there is then again an authority to detain. And then section 17F sets out a number of powers in respect of recalled patients. That's MS 494. Nothing, I think, particularly turns on the language of this provision for the purposes of the issues in this appeal, but the Court will see subsection 4 provides for revocation of the CTO and essentially sets out a process in subsection 6, if the patient's not been released nor the community treatment order revoked by the end of a period of 72 hours following recall, the patient's then released but remains subject to the community treatment order. So there again in subsection 7 we have the language of being released but subject to the CTO. And then section 17... sorry, I should just draw your attention, top of MS 495, subsection 8B, references to being released shall be construed as references to being released from that detention and accordingly from being recalled to hospital. And then section 17G, MS 496, provides for the effect of revocation. And effectively, the liability to be detained ceases to be suspended and is again reactivated. The only other provisions relevant to community patients before we look at the tribunal's discharge powers are in section 18, MS 498. The majority of section 18 is concerned with the position of patients who are liable to be detained, but section 18, subsection 2, capital A, provides for a limited form of being able to take the patient into custody and returning that patient to hospital, but that's only where the community patient is absent from a hospital to which they've been recalled.
Sorry, Ms. Richards, which provision is that?
Section 18, subsection 2,
2A.
capital A.
2A, thank you.
Yes, it makes it quite clear that there is a power.
There is a power, but it's a power confined to a particular circumstance.
To recalled patients who are not in the hospital to which they've been recalled. So
yes.
Either before they get there,
yes,
or having got there, go AWOL.
yes, and it's triggered by the exercise of the power to recall. And then we have, just in terms of duration of CTO, Section 20A, MS 505. Again, nothing turns on this, but the court will see that the ordinary period of a CTO is 6 months, Section 20A, subsection 1, but that can be extended for a further period of 6 months and then on an annual basis. And as a matter of fact, PJ himself was subject to a CTO which was extended on a number of occasions and was finally set aside or discharged over 3 years after its initial inception. And then Section 20B just sets out the effect of expiry of a CTO. This is MS page 508. A community patient should be deemed to be discharged absolutely from liability to recall, and the application for admission, so that's the suspended Section 3 application, ceases to have effect on expiry of the CTO. The other relevant provisions, therefore, are in relation to the powers of the tribunal. Again, I'm conscious the court will have looked at this in MM.
Can I just interrupt you before you move off these ones and ask you why the provision about under Section 3 is in terms of an application for admission for treatment, and the community treatment order is an order?
I'm afraid I don't know the answer to that question, my lady.
I can give you a history lesson.
But I'm wondering whether it tells, one is in a sort of mandatory language and the other one's in a pre-mandatory language, if you see what I mean, but maybe it doesn't matter.
May I say what my understanding is, and then if anybody disagrees. But before the Mental Health Act 1959, compulsory admissions to hospital under civil powers were done by an order addressed to the hospital. And one of the changes in the 59 Act was to make it an application to the hospital because the hospital didn't have to accept the patient. So the authority to detain comes from the application supported by the recommendations accepted by the hospital. That's the difference.
Got it. Thank you.
Whereas the community treatment order is only really ordering the patient to do something.
Yes, and indeed,
thank you.
In that respect is one of a number of points of difference between the CTO regime and the aftercare under supervision regime, which was directed essentially, although it had certain requirements that could be imposed upon the patient, was directed essentially at securing the provision of aftercare services to the patient. My ladies, my lords, then the tribunal provisions are Section 66, first of all, MS 544.
Now, we're right in thinking, are we not, that the substance of the Mental Health Act is the same in England and in Wales.
Yes.
The difference is that in Wales there is still the Mental Health Review Tribunal, whereas in England the same role is carried out by the relevant chamber of the first tier tribunal.
That's correct.
That's the only substantive difference.
That's the only substantive difference in terms of the Act. There are differences that my learned friend refers to in relation to the codes, because the Welsh Government has promulgated its own code of practice, which doesn't say the same as the English code of practice. It's perhaps also, merely by way of background, pertinent to note that at an earlier stage of this particular set of proceedings, when the matter first came before the upper tribunal and the Welsh Ministers were joined, they sought, in fact, to set aside that joinder, saying that they didn't have anything they wanted to say about the issues, and pointing to the fact that this was not a Welsh piece of legislation, but was a UK-wide piece of legislation for which the sponsoring department was effectively the Department for Health and Social Care. But the Act itself draws no distinction whatsoever other than the tribunal structure. It is slightly different. The tribunal powers are identical, and then there is the single difference in the code of practice, or the single difference of potential relevance. So Section 66, subsection 1CA, halfway down MS 544, provides, skipping over the irrelevant material, where CA, a community treatment order, is made in respect of a patient, and then turning over to MS 545, just below subparagraph H, an application may be made to the relevant tribunal within the relevant period. And then we see on MS 546 in subsection 4, the appropriate tribunal means the first tier tribunal or the Mental Health Review Tribunal for Wales. And then the powers of the tribunal are in section 72, MS 549, subsection 1, and again I'm going to skip over the words that don't concern community patients, where application is made to the appropriate tribunal by or in respect of a patient who is a community patient, the tribunal may in any case direct that the patient be discharged. That's the opening words, and the broad discretionary power to discharge. And then if the court goes down to the bottom of that page, subsection C, here we have the mandatory provisions, the tribunal shall direct the discharge of a community patient if it's not satisfied, and then we see criteria which mirror the criteria for the original making of the CTO, including at little 4 that appropriate medical treatment is available for him. So those are the discharge provisions to which I will obviously return in due course.
And discharge means what exactly, Ms. Richards? Does it mean discharge from all liability under this Act?
Effectively, yes. It means discharge from liability to recall, the effect of which, although the Act somewhat curiously doesn't say this in terms, is that the CTO falls away because liability to recall is an inherent part of the CTO. And the effect also is that the suspended admission application under Section 3 also comes to an end. I think we see that. We would see that in the volume 5 of the Supplementary Authorities bundle, which is Supplemental MS, page 9. So it's section 23(1)A.
Application for admission for treatment ceased to have effect.
Yes.
Yeah.
That's helpful. Thank you.
So having dealt with the statutory regime, obviously I'll come back to how we say that should be interpreted in a short while.
But I'm right in thinking, am I not, Ms. Richards, that the tribunal has no power at all to interfere with the conditions imposed by the responsible clinician?
Other than perhaps by way of non-statutory recommendations or advice, but your ladyship is correct, yes. It is not open to the tribunal to vary or revoke the individual conditions themselves.
So they can't say, we discharge unless a particular condition of the CTO is changed. They can't say, we refuse to discharge. A condition of our refusal to discharge is that a particular condition of the CTO is changed.
What they can say, and I will come back to this when I deal with the tribunal powers point, but it's dealt with in some parts of Mr. Justice Charles' judgment in the upper tribunal decision. What he envisaged was that if an issue about a CTO comprising an unlawful or amounting to potentially an unlawful deprivation of liberty arose for the first time before the tribunal, he wouldn't expect the tribunal simply to leap immediately to exercising its power to discharge, but would expect the tribunal potentially to adjourn the case, invite the responsible clinician to consider the position. The responsible clinician has then the power to vary the conditions, to withdraw any of the conditions. And that might be a practical means of changing the concrete situation of the patient so that there is no longer a deprivation of liberty. The responsible clinician may, of course, elect not to do that, in which case the matter would then be considered by the tribunal, which would have, we say, the power, arguably the duty to discharge in certain circumstances. But I'll deal with that if I may.
Please.
When I come to that.
Sorry, I took you out of your course.
No, that's quite right. So I just wanted to deal with a handful of factual matters. You've got the summary of the facts, obviously, in the Statement of Facts and Issues, paragraphs 2 to 9, MS, page 56. And I don't ask you to go back to that. The chronology in terms of the CTO is that it was imposed on the 30th of September 2011, and that resulted in PJ being placed in a care home, which was an institution for up to 10 adult males with a diagnosis of learning disability and challenging or offending behaviour. Placement in that home is not limited to those who have come via the Mental Health Act CTO route. Can I just ask you to look, first of all, at the CTO itself briefly? It's MS 253, that's the core volume, Appendix Part 1. Page 254 is the MS page, page 81 is the relevant page within the appendix. So page 80 is where it starts. So the court will see that the CTO begins on page 80, MS 253, sets out the responsible clinician's view as to the criteria being met. And then over the page 81, MS 254, halfway down the page, we have the conditions. Firstly, we have the mandatory conditions, in other words, those which must be imposed by virtue of section 17b3. And you see that printed on the form under the heading conditions to which the patient is to be subject by virtue of this community treatment order. And then we have the patient is also to be subject to the following conditions, if any, under section 17b2 of the Act. And here we have the conditions imposed by the responsible clinician to reside at the named care home with care/nursing home and adhere to rules of residence at the home. 2, to abide by, in other words, obey or conform to, the joint Section 117 care plan drawn up by the MDT, the multidisciplinary team. And then 3, to abide by, again we say that makes it clear that the patient must conform to or adhere to, the risk mitigation plans for community, I'm not quite sure what the next, access with regard to levels of staff supervision.
Yeah.
And if the, so those were the conditions. If the court puts away core volume and Appendix 1 and turns to Appendix Part 2, MS page 286. This is one of skeletal arguments drafted on behalf of the patient PJ. It's page 113 of Appendix Part 2, MS 286, paragraph 20. It's a useful summary of the provision of the core factual matters. Requirement of residents' adherence to rules, within the unit all internal observations rigorously implemented and documented, whereabouts monitored at all times, time-out policy in operation, escorted by staff for all community outings. Over the page, all unescorted leave must be agreed, and at the time of the tribunal hearing you'll see there was a very limited amount of unescorted leave that had been agreed. F, an absconding protocol and restraint techniques envisaged as a last resort. G, he's returned to the care home with additional staffing as appropriate if presenting with challenging behaviour. H is breathalyzed. And then you'll see reference there to his unescorted leave having been stopped for a month in June 2013 and his own wishes having been overridden. And you'll see at L, in his own terms, in his language, his understanding of the effect of the CTO. Those facts, which are not, I think, in dispute at all, are drawn from the risk mitigation plans to which the condition, the CTO, made express regard. And I would just ask you, as a final set of factual material, to turn to those. They are MS page 408. my apologies, MS 404, page 231. We have a series of risk mitigation plans which deal with different aspects of challenging behaviour. And so the first on MS 404 is concerned, you'll see it from the title, with sexually inappropriate behaviour. That's towards the top of the page under the heading Risk Management Plan number 1. And if the court turns over to page 406, you will see at paragraph 2, a few lines down from the top of the page, is to be supported on all community outings by experienced, well-informed male staff. Skipping down to paragraph 6 on that page, all unescorted leave must be agreed by the RC and the social supervisor. 7, any instances of absconding behaviour should be immediately reported to all relevant parties, including on-call managers and police. And then 8, all internal observations to be rigorously implemented and documented. And then if you look down the various bullet points, about halfway down those bullet points, you'll see reference to if he attempts to abscond, CPI techniques may be used to intervene if deemed necessary, only as a last resort if other diversion techniques have been utilised. Escorted trips should be adequately staffed in line with supervision levels. There's got to be an assessment by the nurse prior to any community outing. If he presents with any challenging behaviours whilst out in the community, he's to be returned to the home with additional staffing provided by the unit as appropriate.
And what does CPI stand for?
I think it's the Crisis Prevention Institute. I think that's certainly an acronym in this law which sets out various techniques through from diversion to restraint. And then we have a second risk management plan on page MS 408, page 235. This is titled Escorted Community Leave.
Sorry, where do we find that?
MS 408.
Thank you.
Towards the top of the page we have the title. And then over the page, you'll see bottom of MS 409, the very last sentence, paragraph number 1, his mental state will be assessed prior to the commencement of escorted leave. If his mental state is not stable, activity will not commence. Top of the next page refers to him and the escorting male member of staff. Under no circumstances will he have female staff. Will have parameters of leave explained, reason, venue, duration of trip. If risk increases to factors identified above, unescorted leave should be stopped immediately and the MDT and multi-agency parties informed. 5, there's a debrief then following all leave by the escorting male staff. And then at 8, again, we get the reference to absconding behaviour. We then have risk management plan number 4, which is said to deal with physical and verbal aggression, MS 411, page 238 of the appendix. And just turning to page 412, MS 412, about a third of the way down the page, we have the title Risk Management Strategies to be Implemented. And then the first point is his whereabouts is to be monitored at all times. He's currently on 15 minutes observations within the unit. 3 refers to de-escalation by asking him to remove himself. 4 refers to, again, staff implementing taught CPI techniques. And 5 to him having to retire to his bedroom to calm down. And then we get the risk management plan for absconding on page MS 414, page 241 of the appendix. And the relevant page is page MS 415, page 242. Again, these are now largely repetitive of the earlier ones, but this is specifically in the context of absconding. And we see confirmed at 6, all unescorted leave must be agreed. If he attempts to abscond, CPI techniques may be used to intervene if deemed necessary as a last resort under duty of care. And then the final risk management plan is concerned with alcohol management. That's MS 417, page 244 of the appendix. And we see on page 418, MS 418, page 245 of the appendix, towards the top of the page, there's an agreed level of alcohol consumption to be agreed by him and the consultant psychiatrist. And then 3 refers to the requirement for an escort. And then 4, if risk increases, unescorted leave should be stopped immediately. And then 5 provides that when he returns, he can be breathalyzed. 6, his room can be searched, and so on. So those are the risk management plans to which the CTO made express reference and required him to abide by. There is also, and I'm just going to give you the reference to this, I'm not going to take you to it, but MS 350, which is Appendix 2, page 177, the social circumstances report prepared for the tribunal hearing refers in very Cheshire West-like terms to PJ having been under fairly consistent observation and boundaries since his index offence. And you would have seen the reference to his unescorted leave being stopped for a month. I'll obviously come back to my learned friend's legal arguments, but we say if the correct test to apply, as we submit it is the Cheshire West acid test, the requirement for complete or continuous supervision and control and an absence of freedom to leave, those criteria are plainly met in the circumstances of this case and are met as a result directly, or are in place as a result directly of the CTO. So, my ladies, my lords, those are the relevant factual matters upon which we rely. Can I turn then to the first main argument and what we say are the relevant principles of construction? Again, I'm conscious that this will be familiar territory to the court from the hearing in MM.
Well, for 4 of us. For
4 of you, yes. I will go, but relatively briefly, to the cases which, or some of the cases we refer to, not all of them. And I'm conscious that there are, I think, 2 more recent decisions of this court. One, a judgment of my Lord Lloyd Jones in B, Algeria, and one, a judgment of my lady in the prison smoking case, which also refer to this line of authority. We haven't put those in the bundle, but I'm sure the court will be familiar with them. So the question, the correct approach to the construction of these provisions of the Mental Health Act, we say, is as follows. That a power that has been conferred by Parliament in general terms, as this provision has, is not to be taken to authorise the doing of acts by the donee of the power which adversely affect the rights of the citizen unless the statute makes it clear that such was the intention of Parliament. And that's a formulation drawn, I think I'm right in saying, from the case of Pearson, which is then cited in Sims and a range of other cases. So I will, I hope, not inconvenience the court if I take you to the Sims case. Obviously, if the court doesn't need to see any of these authorities, I'm happy not to, but it is an important authority and it sets out the principle clearly and helpfully. It's volume 3, tab 27, or MS 1429. And if the court turns to MS 1444, just before we get to the much cited passage from Lord Hoffman's judgment, the court will see on the right hand side, on the left hand side, MS 1444 between D and G, the judgment there of Lord Stein, reference between E and F to the principle of legality. And then we see that fleshed out by Lord Hoffman on the opposing page, MS 1445, between E and G. Parliamentary sovereignty means that Parliament can, if it chooses, legislate contrary to fundamental principles of human rights. The HRA will not detract from this power. The constraints upon its exercise by Parliament are ultimately political but not legal. But the principle of legality means that Parliament must squarely confront what it is doing and accept the political cost. Fundamental rights cannot be overridden by general or ambiguous words. This is because there is too great a risk that the full implications of their unqualified meaning may have passed unnoticed in the democratic process. In the absence of express language or necessary implication to the contrary, the courts therefore presume that even the most general words were intended to be subject to the basic rights of the individual. So that's the core principle of legality. And then if the court would then just turn in volume 1 of the authorities bundle, tab 6, MS 750, to this court's decision in AXA General Insurance and HM Advocate. And if you would turn, please, to MS 827, which is paragraph 151 onwards in the judgment of Lord Reed, page 945 in the law report. You'll see set out in paragraph 150 the citation from Lord Hoffman in Sims, and then the top of the next page, paragraph 152, the principle of legality means not only that Parliament cannot itself override fundamental rights or the rule of law by general or ambiguous words, but also that it cannot confer on another body by general or ambiguous words the power to do so. And then we have the reference there to Pearson, and at little c, in the same case, unless there's the clearest provision to the contrary, Parliament must be presumed not to legislate contrary to the rule of law. And obviously that's then being put, I think, in a number of different ways, but to the same effect in other authority, I think by my Lord Lloyd Jones in B. Algeria, that Parliament is presumed not to interfere with the liberty of the subject without making such an intention clear. We say that must be particularly borne in mind when the fundamental right is one of physical liberty, as here. We've set out in our written case reference to Benyon on statutory interpretation and some other authorities. I'll just give you the references, if I may, without taking the court's time up by going to them. The reference to Benyon in our written case is at MS page 1980, Authorities Bundle, Volume 4, tab 51. And that's the principle that physical liberty should not be curtailed or interfered with except under clear authority of law. And that particular statement was approved by the Privy Council in the case of Selassie. Again, I won't take you to it, but it's the Authorities Bundle, Volume 3, tab 28, paragraph 17, and it's MS, page 1468.
Also, Miss Richards, the elephant in the room is that we are dealing here with orders made in relation to detained patients.
Well, we are dealing here with orders, the effect of which is to discharge the patient from hospital, to suspend the powers of the Mental Health Act that are concerned with patients who are detained, that expressly provide at that point that the authority to detain is suspended, and expressly provide that any reference to detention or detained patient or liable to be detained doesn't apply to the community patient. And we say those are very clear pointers in the statutory language that draw a distinction between that which is contemplated and expressly authorised by the Act for the patient detained in hospital, and that which is permitted by way of conditions under a community treatment order, where the language, we say, what Parliament would have enacted those provisions in fundamentally different terms if it was intended that some form of detention or deprivation of liberty in the community could take place. My Lord, I will come back to that when I look again at
Thank
the
you very
language of
much
the
indeed.
But before I leave the question of the correct approach to statutory interpretation, we say that particular care needs to be taken when the Act that is being construed is concerned not just with physical liberty, but with the physical liberty of those who are mentally ill. And I will just, in that regard, ask you to look at the judgment of Sir Thomas Bingham in Re SC. That's volume 3 of the Authorities Bundle. Tab 30, MS 1528. And the page and the judgment is MS 1532, page 603 of the report. Picking it up at C, first of all, we have reference to the general principles and the fundamental constitutional principles, Magna Carta, and so on. Then at E, we have reference to the position of mental patients and how those who are vulnerable as a result of mental illness may require to be deprived of their liberty. But then this...
I'm sorry, what page are you on?
I'm sorry, my lady, it's page 1532, MS 1532. Page 603 of the report, between F and G,
Yes.
where it said this: powers therefore exist to ensure that those who suffer from mental illness may in appropriate circumstances be involuntarily admitted to mental hospitals and detained. But, and it is a very important but, the circumstances in which the mentally ill may be detained are very carefully prescribed by statute. And then in the same volume, my ladies, my lords, at tab 25, we have the decision of Mr. Justice McCulloch in the Hallstrom case. That's MS 1381.
Sorry, the reference again, please.
MS 1395 is the relevant passage in the report. It's tab 25,
See,
volume
died
3.
last week.
Sorry, 1385 or 95?
1395, my lady. And just picking it up on page MS 1395, below the letter D, you will see the submission there being advanced by Mr. Brooke was that if the meaning of section 3 was ambiguous, the construction for which he contends should be adopted because it enables doctors to do what, in accordance with good modern psychiatric patient, is in the best interest of patients like W, treat them in the community but compel them to accept their medication. So there was a benign purpose argument there being advanced, and the judge rejected that in the next paragraph, saying there is no canon of construction which presumes that Parliament intended that people should be subjected to treatment which others, however professionally competent, perceive, however sincerely and however correctly, to be in their best interests. What there is a canon of construction that Parliament is presumed not to enact legislation which interferes with the liberty of the subject without making it clear that was its intention. And again, that's a statement of principle approved by the Privy Council. I won't take you to it. It's a case called Nidicke or Nidike, the Attorney General of Trinidad and Tobago, but for the court's reference, it's Authorities Volume 2, tab 15, MS 1067-8. And having expressly approved what Mr. Justice McCulloch said, the court, the Privy Council there went on to say that any uncertainty in terms of meaning must be resolved in favour of the liberty of the individual. And so our submission, our principal submission on this part of the case is that given all that's been said in those authorities for many years, and given the particular vulnerability of psychiatric patients, it's vital that any powers authorising their deprivation of liberty be clearly prescribed. And whilst we accept in principle, because this court has said as much in Sims and other cases, that necessary implication may suffice for curtailment of fundamental rights, we do respectfully submit it's difficult to think of circumstances in which anything less than express words would provide a lawful statutory authority to detain a psychiatric patient in the community.
Sims expressly left the door open.
He did.
Possibility.
He did. And there's then the refinement, and I'm not going to take up too much time on it, but there's a refinement in one of the Banquo pieces of litigation by Lord Justice Laws, who suggests that there must be something specific, at least within the statute. He used the terminology of specific authority from Parliament, even in the context of necessary implication. And that's, we have that judgment, the Authorities Bundle, Volume 2, tab 19, MS 1196.
I'm sorry, Ms. Roberts, could I just take you back to Nidicke? What was the paragraph number which approved Mr. Justice McCulloch's?
I think it's 48. Forgive me, my lady, I haven't got it written down. Yes. It's paragraph
Oh, yes.
48. It's MS 1067, bottom of the page and top of 1068.
I see. That was in the main judgment, was it?
Let's check.
Lord Brown.
It's the judgment of Lord Brown. Your
I seem
ladyship,
to remember writing a judgment myself in that case.
your ladyship gave an additional judgment, bottom of page 1071. You agreed, but said a little more about one aspect of the case.
Yes.
And it's also in that paragraph where it said that uncertainty should be resolved in favour of the liberty of the individual. That's bottom of page 1067, paragraph 48. Accepting as we do that Lord Hoffman and Sims left open the possibility of necessary implication, it's nonetheless very clear from the authorities that that is a very high threshold indeed. We've referred in our written case to this court's decision, House of Lords decision in Morgan Grenfell. That's Authorities Volume 3, tab 23. It's MS 1303. Is where the passage starts. Paragraph 44 of Lord Hobhouse's judgment refers and quotes again from Sims, and then over the page at MS 1304, at paragraph 45, we have the passage we've set out in our written case. Picking it up 4 lines down, a necessary implication is not the same as a reasonable implication. A necessary implication is one which necessarily follows from the express provisions of the statute construed in their context. And I think my lady has added a refinement to that context or purpose in the prison smokers case. It distinguishes between what it would have been sensible or reasonable for Parliament to have included, or what Parliament would, if it had thought about it, probably have included, and what it is clear that the express language of the statute shows that the statute must have included. A necessary implication is a matter of express language and logic, not interpretation. So there must be something express in the language of the Act which allows, as a matter of both language and logic, that implication, or not just allows, requires that implication to arise. Again, it's an area which this court has considered in numerous cases. The language in B and DPP, which is referred to in these various authorities and referred to in Morgan Grenfell, uses the terminology of an implication which is compellingly clear, which is perhaps another way of making clear how high the threshold is. And so when one seeks to apply these principles of construction to the Mental Health Act, we make the following submissions. They are set out in the written case, so I'm going to summarise them if I may. We observe, first of all, that the power to impose conditions in section 17b(2) of the MHA is expressed in the most general terms. It is a provision of general words. We submit that there is nothing in the express words of the Act to suggest, still less compel the conclusion, that Parliament intended to create a new form of community detention by empowering RCs to impose conditions resulting objectively in deprivation of liberty. We submit there's nothing, picking up the phrase in the Morgan Grenfell case, in the express language and logic of the Act to support the Court of Appeal's conclusion. And then we do say that the language of the Act is in fact to the opposite effect. Throughout the Act, and I've shown the Court, I hope, some examples in sections 3 and 6 and so on, where the Act confers the power to detain or convey a patient, it does so expressly. I won't ask you to go back to the Act itself, but we've set out in our written case a number of examples in paragraph 28 onwards of the written case, MS 75. So I will, because I need to cover rather a lot of ground in the course of the morning, I take those as read if I may. What we submit in sum is that the scheme of the Act and the references that we do see, the express references to detention and liability to detention, are plainly focused on detention in hospital. And if Parliament had intended to introduce a new form of community detention, we say it would have done so in express terms, and thereby the court would have been able to be satisfied that Parliament had squarely confronted the potential interference with fundamental rights that gives rise to. The Court of Appeal's conclusion was in large part based upon the statutory role of the responsible clinician, and the court may recall that phrase used by the Court of Appeal, the ultimate power of detention, in paragraph 50 of the Court of Appeal's judgment. But that really takes the argument in our respectful submission nowhere. The RC clearly has an express power to make a community treatment order and to set conditions as part of that order and to recall patients to hospital. But that simply doesn't mean, as a matter of logic or language or principle, that the RC is thereby somehow empowered to deprive patients of their liberty in the community.
In fact, am I right in thinking that the responsible clinician is not empowered to detain somebody under Section 3? That is done by an application by the nearest relative or approved mental health professional, supported by medical recommendations, one of which may be from the person who will be the responsible clinician, but need not be,
Yes.
And then accepted by the hospital. And those three things give the authority to detain. Apart from powers of recall and powers of recall from leave, I can't think of anything in the Act which gives the responsible clinician the role of deciding on detention.
No, if the responsible clinician is one of the authors of the two reports, that'll be a matter of accident rather than design of the Act. Yeah. The responsible clinician has the power to effectively, on the basis of his or her recommendations, bring the detention to an end.
Yes.
But the authority to detain is neither stems from the responsible clinician's actions, nor is vested in the responsible clinician. It's vested in the managers of the hospital. Mm. Yes, and Mr. Mount reminds me that there's one express provision, which I think we looked at earlier in section 18 of the Act. No, sorry, it's section 17 of the Act, section 17.3.
Well, that's what I mentioned before.
Leave. Yes, the responsible clinician can direct that the person remains in custody.
Yeah.
But other than that, your ladyship is absolutely right. And what we submit, where the Court of Appeal has erred, and it's an error in which my learned friend's submissions also fall, it's the Hallstrom error, really. It's to jump from the fact that some might regard the ability to deprive a patient of their liberty in the community as a good thing, or beneficial for the patient, to a conclusion that Parliament intended that it should happen. So looking at language, we say no support for my learned friend's arguments, in fact, the contrary. In terms of context and purpose, we've set out some submissions in that regard in our written case at paragraphs 39 to 40, MS 79 to 80. The purpose of a CTO is identified in the Mental Health Act Code. And we say it's a purpose that can be achieved without depriving a patient of their liberty. Perhaps I should just take the court to volume 4 of the authorities bundle. Tab 47, which is the code. And it's page 1925.
Is this the Welsh code?
No, this is the English code. And this isn't the passage about deprivation of liberty. In fact, this is just what sets out what the purpose of a CTO is. Page MS 1925. And it's paragraph 29.5 onwards. Purpose of a CTO is to allow suitable patients to be safely treated in the community rather than under detention in hospital, and to provide a way to help prevent relapse and harm, intended to help patients to maintain stable mental health. And then 29.6 provides a framework for the management of patient care in the community and gives the RC the power to recall the patient to hospital for treatment if necessary. And then, of course, the English code then has the additional provision at MS 1930, paragraph 29.31. The conditions must not deprive the patient of their liberty. Now, I'm not praying the code of practice in aid in support of the language used by Parliament or as a classic aid to statutory interpretation. I accept that that would go too far. But my learned friend argues that our contentions would somehow subvert the purpose of the CTO regime. He relies upon no evidence to that effect, and indeed mine submissions and evidence are to the contrary. But I simply ask the court to note, if one's looking to see what's said by the Secretary of State for Health in the English Code of Practice, you will see the purpose there defined and clearly not envisaged that that purpose would be subverted if the conditions were not permitted to amount to a deprivation of liberty. On the contrary, the opposite conclusion is there set out. And so it simply doesn't follow that if community detention were not to be permitted or authorised by the Act, that the purpose of the CTO regime would somehow be undermined. There are two additional factors which we've set out in our written case, just bearing upon this question of the statutory power. The first is this: the CTO regime was, as the court will have seen, introduced as part of the Mental Health Act 2007. And that's the same legislation that introduced the Dole's safeguards following the decision of the European Court in HL. If the court just takes up volume 1 of the authorities bundle, it's not in dispute that the CTO provisions were inserted by the 2007 Act. If the court just turns to tab 3, MS 577, you will see there that the amendments to the Mental Capacity Act introduced in the same piece of legislation, i.e. the Mental Health Act 2007, expressly and squarely confronted and addressed and enacted in express words authority to deprive of liberty in the community. And in our respectful submission, if you have a single statute, the 2007 Act, introducing these two new provisions, the CTO regime into the Mental Health Act, and then the Dole's provisions into the Mental Capacity Act, it would be very odd for Parliament to use the express language of authorising deprivation of liberty in the one, but to remain completely silent on the other, and yet be presumed to have intended community detention to be authorised. So we say that is a further factor relevant to the construction of the statute. The second factor that we've referred to, and I don't suggest, again, that this is relevant to the pure issue of construction, but maybe relevant to considerations of purpose and context and some of my learned friends' consequentialist arguments. It is clear, we say, from the material that we've referred to and that Mind has referred to, that the government never intended CTOs to impose some form of community detention. And you've got express reference to consideration by the Joint Committee on Human Rights and then ministerial responses on behalf of the government to that in our written case. I will just give you the reference. It's Authorities Bundle Volume 4, tab 42, MS 1885 and 1895. With those submissions thus far have been based upon the conventional principles of statutory construction without touching upon the implications for Article 5. I can take the Article 5 arguments, I hope, relatively quickly because they are set out in our written case in some detail.
Can I just ask
Lady, yes.
one more thing? There must presumably have been travaux préparatoires before the 2007 Act discussing proposals for community treatment orders. They didn't call them that then, they called them something else. But have we got any of those in our materials? I can't see them.
I don't think we have. We have a handful of parliamentary materials which are looking really at what the primary purpose was in terms of revolving door patients. And then the extract from the Joint Committee's report. Can I just double check?
Well, I'm a little bit concerned because we don't like to look at Hansard if we can possibly avoid it, but we're usually perfectly happy to look at government and other consultation papers and reports that lead to innovations such as this.
Yes, I think any of us have put that material in, but we should double check to see whether there's anything relevant in it. I'm sorry that I can't give you a clear answer as to whether there is or is not. I think the most we had found in our researches was the material that I've referred to, which is in the context of the Joint Committee's concerns being expressed in the government response.
Yes.
But your lady's right to say that it's possible that there may be more. Clearly it's a requirement that the Mental Health Act, which was introduced, or aspects of which were introduced so as to be in conformity with Article 5, should be read and given effect to in a way which is compatible with Article 5. We've set out our submissions in that regard in our written case from MS 81 to 87. Check I've given you the right reference there. Yes, so it's paragraphs 42 through to 59. Because I've still got a number of issues to deal with, I'm going to take this, I hope, as quickly as I can. The Court of Appeal's decision in B in the Secretary of State for Justice, which I'm, again, 4 members of this court will have looked at probably extensively for the purposes of the MM appeal, is in the Authorities Bundle Volume 1, tab 7 at MS 837. I will just ask you to look at that, if I may. So picking it up in the judgment of Lady Justice Arden, as she then was at MS 840, we see the general points made in paragraphs 3 and 4. Act intended to give effect to rights guaranteed by the Convention. Act must be interpreted so as to be compatible with Convention rights. And then paragraph 7 on page MS 841 refers to the extensive procedural guarantees that compliance with Article 5 entails, the requirement to avoid arbitrariness and detention in accordance with domestic law. And then further down the page, paragraphs 8 and 9, the requirement of a review of lawfulness by a suitable judicial procedure. There is then extensive reference to HL at paragraphs 11 and 12 over the page on page 842. But then picking it up at paragraph 14 on MS 843, Lady Justice Arden identifies 4 conditions to be satisfied for the detention of a person of unsound mind to be lawful. And for the purposes of this submission, we rely on the 4th condition. The criteria for detention must be prescribed by law, that is to say, be set out in legislation so the patient knows what they are and can bring effective proceedings to challenge his detention. The prescribed by law component in the context of Article 5, again, has been considered extensively by the European Court of Human Rights. I'll just, if I may, give you a handful of references. In Ashingdane, Authorities Bundle Volume 4, tab 34, MS 1631, paragraph 44. In HL, Authorities Bundle 4, tab 37, MS 1739, at paragraphs 114 to 15, and then paragraphs 119 to 124. And then the case of Buzadji and Moldova, which is Authorities Bundle 4, tab 36. And I will just ask you to look at this because it may not be depending upon whether it was cited in an M, but it may be a less familiar authority. MS 1689.
This was the house arrest, wasn't it?
Yes. Your ladyship has had to be. For present purposes, I might need to come back to it, but for present purposes, I just refer to what's set out at paragraph 84, which refers to the fundamental nature of Article 5, and then the 3 strands of reasoning running through the court's case law. This is just above the letter D on the page. And picking it up between D and E, the repeated emphasis on the lawfulness of the detention, both procedural and substantive, requiring scrupulous adherence to the rule of law. That's the 2nd strand of reasoning. And then the 3rd, the importance of promptness or speediness for the requisite judicial controls. And then in the context of the Article 5.4 and the importance of the entitlement to review of lawfulness of detention, there is also the MH case. Again, I'm just going to give the court the references to that. It's Authorities Bundle tab 38, MS 1774 to 5, paragraph 74 to 76, and paragraph 82 on MS 1777. And in the concept of law prescribed by law in the Convention has an autonomous meaning. We see that from the AXA general insurance case. Don't ask the court to go back to it, but that was volume 1, tab 5, MS 785, paragraph 21, which means that provisions must be accessible, clearly expressed, and not arbitrary. And in short, we say that detention pursuant to an act which is silent about detention, in the context with which we're concerned, CTAs cannot suffice for the requirement for lawfulness. And then we've set out in our written case a series of submissions, which I won't repeat, but will simply rely upon from the written case, about what we say is the absence of any clear criteria for deprivation of liberty in paragraphs 48 onwards through to 51 of the written case. And then, in terms of safeguards, picking matters up at paragraph 52 on MS 84 in our written case, we say that coupled with the absence of clear criteria for detention, and thus non-compliance with Lady Justice Arden's 4th condition, we have a clear absence of safeguards for the reasons set out in paragraphs 52 onwards, if the Court of Appeal's decision is right, that we have a species of detention that cannot be challenged before the Mental Health Review or first-tier tribunal. And we've made a number of observations about the adequacy of judicial review as an alternative in paragraphs 53 onwards. Again, I'm not proposing to go through those. If I can provide one additional citation for the point made about the burden in paragraph 58 on MS 86, we've referred there to the case, the decision of the Court of Appeal in Re H. Can I just add to that the decision of the European Court in the case of Reed, Volume 4 of the Authorities Bundle, tab 39, MS 1804-5, paragraphs 70 to 73, where the European Court makes a similar point. And so we say that if the Court of Appeal is right about this second point, and I will come back to the jurisdiction point and the tribunal's powers in a moment, we have a situation in which Parliament would have created a form of a detention which could not be challenged before the tribunal, but only by way of judicial review with all the disadvantages identified in the written case. And we say again that simply is a further pointer to the fact that Parliament cannot have intended that to be the position under the Act. My ladies and my lords, before I leave this issue and deal shortly, as I'll have to, with the other issues, can I just make a handful of observations in response to my learned friend's submissions on this point? Firstly, fundamental to my learned friend's case on the statutory authority point is his assertion that it would subvert the CTO regime if RCs couldn't deprive patients of their liberty in the community. We say that the respondents identified no material whatsoever to support that assertion, and it's effectively answered in any event, evidentially, in the submissions and evidence filed by Mind. It's also built on a number of assumptions or assertions, for example, that CTOs are inherently more benign and less restrictive than detention pursuant to Section 3, again, for which there is no evidence put forward by the respondent, but there is material to the contrary from the intervener. We say that whether or not CTOs should permit deprivation of liberty may well be an important question of policy on which people might reasonably hold different views. But what matters for the purposes of interpreting the Act is what Parliament considered. And that takes us back to the requirement for Parliament to squarely confront an interference with fundamental rights. And if it had concluded that deprivation of liberty was the right policy outcome and was necessary in order for CTOs to function, we would have seen some form of express provision to that effect. The second point made by my learned friend that I wanted to just respond to at this stage is this. He suggests that CTOs that authorise detention in the community do not, in fact, take away any fundamental rights. And he relies on the fact that patients will have, up until that point, have been detained pursuant to Section 3. The short answer to that, we say, is that the fact that Parliament has expressly legislated for detention in hospital under Section 3 cannot mean that other forms of subsequent detention not in hospital can be authorised without Parliament having squarely confronted that issue. We know from all the case law that provisions affecting fundamental rights must be strictly construed. We know that Section 3 is concerned only with the authorisation of detention in hospital. And whilst it may be a precondition for the imposition of a CTO that the patient is a Section 3 patient, once the CTO is imposed, we know from the Act itself that the authority to detain is suspended. The third general point from my learned friend's submissions I wanted to address at this stage is his assumption, which really runs through all the arguments that he deploys, that a CTO is necessarily less restrictive than detention under Section 3. But there is absolutely no evidence that that's true in PJ's case, where the CTO, as you will have seen, provided for very substantial inroads into his right to liberty in a way which might easily be more restrictive than the position of a patient on for example, a low secure unit in a hospital. And there's no evidence that that is in fact the position more generally. But even if a CTO was, as my learned friend seeks to characterise it, inherently a liberalising measure, it simply wouldn't follow that the Morgan-Grenfell test was satisfied and that Parliament must be taken to have included in the condition-making power a power to detain.
I suppose there's one difference, isn't there, in relation to the forcible imposition of treatment,
Yes.
which can happen in hospital under Part 4 of the Act. I'd need to remind myself because the provisions about compulsory treatment under CTOs are incredibly complicated.
Yes, they are. I think we have dealt with them in passing in our written case,
Yeah.
but not in detail. I can, if I need to, give your ladyship the provisions when I reply at the end of the day. We'll detail them for you.
Or we can look them up. But that is one way in which being detained in hospital is different from being on a CTO.
Yes. Yes. But in terms
Otherwise,
of...
of
yes.
course, the hospital might be a lovely, free and easy place where you could wander around the grounds and go out to the shops whenever you fancied it, whereas the care home might not be.
Well, exactly. And
It all depends on the facts.
a care home, as indeed PJ's care home was, may be locked and have all sorts of restrictions in place. A low secure unit, particularly if it's in a rural setting, where he previously was, when he was sectioned, was a rural setting, may be much more open and liberal in terms of its regime. So it's simply not open to my learned friend to build a case based upon such assumptions. And then the final point I want to deal with before I turn to the other arguments is my learned friend's submission that there would be something highly problematic for responsible clinicians if they were not able to impose conditions that would amount to a deprivation of liberty. It's paragraphs 28 to 29 of his written case, where he says, look, under the Dole's regime, there's a whole range of specialist assessors who have to undertake the exercise of determining if something amounts to a deprivation of liberty or not. And he says it would be too difficult for responsible clinicians or AMPs to have to decide if something constitutes a deprivation of liberty and thereby adjust the conditions accordingly. That is with the greatest respect, somewhat fanciful. If a care home manager is asked to confront, as they do, or the manager of a supported living placement has to confront, as they do, the question of whether something's a deprivation of liberty in order to decide whether to seek a Dole's authorisation, then it shouldn't be beyond the powers of the responsible clinician to do likewise. The question for the responsible clinician will simply be, am I imposing conditions which cumulatively mean that the Cheshire West acid test is satisfied? My ladies, my lords, that's the main argument. I'll have to deal, because I've got limited time available, very shortly with the other arguments. Tribunal's jurisdiction, so the second part of the Court of Appeal's judgment, the second part of our appeal. We say, and we have three overarching points in that regard. Firstly, we say the Court of Appeal erred in its judgment on the powers of the tribunal. It mischaracterised the tribunal's approach as involving an assumption of jurisdiction when the upper tribunal was simply looking at how properly an undisputed power of discharge under Section 72 should be exercised. We're not relying on some kind of concealed power, which is the suggestion that my learned friend makes in his written case. Our case is not that by virtue of the Human Rights Act, a jurisdiction is conferred upon the tribunal that doesn't otherwise exist. Our case is simply that the terms of the Human Rights Act govern the proper approach to the existing jurisdiction. Second overarching point, we say the RC's power to impose conditions flows from the making of the CTO. That on its face has to specify the conditions. And so the practical effect of a tribunal decision not to discharge the community patient is to uphold the CTO and its conditions. And if we're right then about that, the tribunal is upholding a CTO with conditions that give rise to an unlawful deprivation of liberty and perpetuating an unlawful state of affairs. And so that leads to the third overarching point. We say, on any view, the tribunal has the general discretion to direct discharge in any case. And we say that is simply a discretion that must be informed by the positive duty imposed upon the tribunal as a public body not to permit an unlawful state of affairs to continue, positive duty on the state to prevent a continuing deprivation of liberty of which the state becomes aware. That positive obligation is spelt out in Stork in Germany and a host of other ECHR cases. We say there is an alternative route to the tribunal's jurisdiction in terms of the criteria and the requirement that appropriate treatment be available. And we say that there is no damage done to the language of that part of Section 72 to read into it a requirement that the available treatment, appropriate treatment, is lawful treatment. We've set out those arguments in some detail in the written case, and so I'm not going to seek to repeat those. But just coming back to, I think, a question posed by my Lord Wilson earlier this morning, it's not our case that the tribunal would simply have to discharge the patient every time such an issue arose. As I indicated in my answer to Lord Wilson earlier, we say, falling back upon what Mr Justice Charles articulated in his judgment in the Upper Tribunal, MS 244, paragraph 143, if the tribunal considers that the conditions of a CTO might give rise to an unlawful deprivation of liberty, the appropriate step is it will adjourn. It will allow the responsible clinician and others to take steps to adjust the arrangements to ensure that the conditions are lawful. The RC has the opportunity then to consider, if this is a patient who's already on a CTO, the power of variation or of recall or revocation. And only if, following that exercise, the regime is unaltered and the RC has said, well, I'm not going to change anything, the conditions remain, only then will the tribunal need to consider the exercise of the power of discharge.
Well, would that satisfy the Strasbourg requirement for review of deprivation of liberty?
Well, it would if, contrary to the Court of Appeal's conclusion, the tribunal were permitted to consider the lawfulness of the detention, which is what we say. It would then satisfy the Article 5.4 requirement. Because you'd have access to the obvious body with the appropriate expertise, appropriate speed of access, and so on. Can I then turn to my learned friend's argument, as set out in his original written case, that the touchstone for whether there is a deprivation of liberty in the community is not the acid test articulated in Cheshire West, but is based upon a comparison between the situation of the patient under Section 3 and the situation of the patient in the community. We say that amounts to a fundamental rewriting of the decision of this court in Cheshire West. I do just need to ask the court to take up Cheshire West. It's in volume 2 of the authorities bundle. At tab 9, MS 885. And I'm optimistic that the court is very familiar.
We're not in the controversial bit of Cheshire West here, are we?
I don't think so, my lady, no. And so I just want to touch on a handful of the passages as quickly as I can. So paragraph 34, page 905, records the submission, in fact, of Mr. Gordon.
Well, yes, there is an irony about
There is an irony,
yes.
yes.
This is the bar for you.
Exactly. But it's not the fact of his submission, but the court's own and your ladyship's own acceptance of the submission upon which I rely, that you shouldn't confuse the concept of deprivation of liberty with the justification for imposing such a deprivation, and that's the conclusion that your ladyship effectively reaches endorsing that submission. And then paragraph 36, the universal character of human rights, bottom page 905. And then turning to paragraph 41, Your Ladyship then reviewed the relevant authorities. And I just invite attention to just above letter C on MS 907, paragraph 41, the fact that these were social care settings with relatively open conditions, PJ's was social care but not particularly open, was no more determinative than had been the open hospital conditions in Ashingdane. Paragraph 42, purpose of confinement is not relevant. And then over the page, the discussion in my lady's judgment at paragraph 45 and 46, what it means to be deprived of liberty must be the same for everyone. And in that particular context, obviously, the distinction that was being identified there was the distinction between the capacitated and the incapacitated. And then 48 and 49, the acid test, and the two features there, continuous supervision and control, and not free to leave. And then paragraph 50, halfway down paragraph 50, MS 909, referring to submissions made by the National Autistic Society in Mind, picking it up at the sentence, they suggest the person's compliance or lack of objection is not relevant. The relative normality of the placement, whatever the comparison made, is not relevant, and the reason or purpose behind a particular placement is not relevant. I agree with that approach. And then paragraph 54 down to 56 on page 911 identifies that the key question is it's the constraints that matter, my lady's language in the bottom of page 911. And then similar observations in the judgments of Lord Newburger and my Lord Kerr, which I won't, in the interest of saving time, go through. So the case law and the test to be applied, we say, is absolutely clear. Of course, in individual cases, it might give rise to difficulties of application, but that's going to be the case whatever test is articulated. Doesn't mean it's not the test. Dealing then with my learned friend's submissions on this point, first of all, he says the question of whether there's a deprivation of liberty is one of context. Well, to some extent that's true, but the context of Cheshire West was placement in a social care setting, exactly the context here. And the test was derived from a range of authorities, all concerned with principles applicable to the placement of persons of unsound mind, precisely the context with which we are concerned. That the particular statutory regime to which the person may or may not have been subject doesn't change the concrete situation. And that's very clear from all the Strasbourg authorities. Different countries, a range of different statutory regimes, but a single identifiable test as to whether there is objectively a deprivation of liberty. Secondly, my learned friend submits, this is paragraph 69 of his written case, that there has to be a distinction between deprivation of liberty in hospital and a lesser restriction on liberty. We say that is an attempt to introduce the purpose, benevolent purpose test rejected in Cheshire West. And the court already has my point that it simply doesn't follow as a matter of law that placement in a care home or a social placement will necessarily be less restrictive. And in any event, my learned friend's submission is inconsistent with Strasbourg case law in that regard. The Ashingdane case, which I just give you the reference, volume 4, tab 34, MS 1616, paragraphs 40 to 42, They're looked at deprivation in high secure detention under the Mental Health Act in high secure conditions, in open conditions, all still a deprivation of liberty. And then the Bazadji case, I will briefly ask the court to go back to that, the house arrest case, volume 4, tab 36, MS 1689. Sorry, that's the wrong reference. At 1693, paragraph 103, the court insists in its case law on an autonomous interpretation of the notion of deprivation of liberty. So it's not a variable concept. and indeed on the facts of that case, the fact that house arrest was more benign than the previous detention to which the individual had been subjected did not mean that the house arrest was not itself a deprivation of liberty. And then my learned friend's third point is, he says, the case ought not to be decided in a way that would expose the patient to greater restriction of their liberty. Leaving aside the assumptions that underpin that, which we say are misplaced, even if right, the fact that in some cases it might be desirable to detain a patient in a different, less restrictive setting simply cannot create the lawful authority to do so if that authority does not exist. And the desirability of what my learned friend says is a better situation of community detention is squarely a matter for Parliament and not the court. And then my learned friend suggests that his approach is necessary because it avoids a patient having to be recalled to greater restrictions. We submit that's not necessarily the case. And we invite the court to consider in particular the submissions that Mind makes about various different ways in which patients can be tested out in the community without involving a deprivation of liberty under a community treatment order, not least by using Section 17. But if a patient did have to be recalled to hospital or have to remain in conditions of greater restriction, that would be because Parliament has determined that patients requiring such high levels of restriction, requiring detention in order to receive treatment and so on, should only be detained in hospital and not elsewhere. Three further points on this ground. My learned friend, in paragraph 75 of his written case, seeks to draw an analogy with the case of Austin, Kettling case, and with the arguments that were advanced for the intervener in Cheshire West. My lady may recall a distinction between what Mr. Bowen called type 1 and type 2 cases in Cheshire West. That's nothing to do with the situation with which we're concerned. That argument was looking at certain types of restrictions on liberty which could never be justified under Article 5 because they didn't fall within the list of permitted deprivations of liberty. My learned friend rightly concedes that we are here dealing with deprivation of liberty of persons of unsound mind, which falls squarely with 5.1e. So the Austin argument and Mr. Bowen's distinction between type 1 and type 2 cases in Cheshire West is neither here nor there. Cheshire West does, however, make clear, and this is paragraph 57 of my lady's judgment in Cheshire West, that persons deprived of their liberty require protections and safeguards. And the fact that a person might, depending upon the particular circumstances, be moving from conditions of greater restriction to conditions of less restriction, on a different set of facts, it might be the other way around, does not mean that they are in any less need of protection and safeguards. But the final point on this part of my learned friend's arguments is this. On his case, you could have two individuals, adult males, with learning disabilities and challenging behaviour, subject to an identical regime in the identical care home. We take PJ's own care home, 10 people could be accommodated there. We could have 10 males there under a CTO. On my learned friend's argument, not deprived of their liberty. 10 individuals there through a different route, an MCA route, subject to the same regime. Cheshire West would bite deprived of their liberty. We say it cannot be right that you could have two people in identical circumstances, one under a CTO, one not, and reach a different conclusion as a matter of fact as to whether there was a deprivation of liberty. That leaves me finally with my learned friend's new point. I don't know whether the court had any opportunity at all to read our written response to that in advance of coming in. Well, I'm grateful. In that case, I won't go through the note, but our arguments thus far on this point are set out comprehensively in it, leaving aside what we say is the inconsistency or tension between that and my learned friend's main argument. We say the suggestion that conditions are non-mandatory is both based upon a misunderstanding of the way in which that term has been used in this context, but in any event is just wrong. The whole purpose of the imposition of conditions, as the language of section 17b makes clear, is that the patient is expected to, is required to comply with them. What my learned friend's argument ultimately comes to is simply this, that there is no direct means of enforcing those conditions. There's no sanction automatically tied to a breach of condition. Well, that might be right, but that tells us nothing about whether it is or is not a deprivation of liberty. And we have suggested that the two authorities upon which my learned friend relies do not, in fact, assist his argument for the reasons we've there set out. My ladies, my lords, unless I can assist further, those are our principal submissions.
Well, you've done very well, Ms Richards, to get it all into the time allotted, slightly under the time allotted, despite the questions that have been thrown at you. Thank you. Mr Munt? Thank you. Ms Rirapi.
Thank you, my lady, thank you. And I hope not to be able to definitely finish my submissions in the time allotted. I don't particularly want to delay the court with anything that clearly repeats what Ms Richards has said. But as Mind has made clear in its written submission, it does support the appeal of PJ as presented by Ms Richards and Mr. What I propose to do in the few moments that I have available is to possibly most usefully to signpost where our material is to be found, and then possibly also in the time to summarise some of the headline points from the submissions that we make and the evidence that has been filed by Mind, which supports the appellant's submissions and of course those that we make also. So in terms of the signposting, if I might simply start by saying this, that all our documents are in the core volume. Our application is at MS 257 and our written submissions are at MS 125. The statement of evidence that was filed by Alison Cobb at MS 145 with an exhibit at 151. And these are all behind a tab that's called Case for the Proposed Intervener, because at the time that they were filed, we were a proposed intervener, and we were fortunately given permission subsequent to the preparation of the bundle. So Mind has sought to intervene not simply because it has some general points to make against CTOs. Mind is a campaigning organisation which is intimately involved in the running of the Mental Health Act and the parliamentary process that led to that Act, and indeed to the introduction of community treatment orders as well. Mind effectively campaigned, and it's an open secret, it's no secret, I should say, that Mind campaigned against CTOs. There were great concerns around the possibility of forcible treatment of community patients, and indeed also of deprivations of liberty of community patients, and that caused grave concern, which resulted in a lot of activity around that at that time. And so what Mind hopes to do in this intervention is to offer some context to its concerns as expressed in relation to CTOs generally, but also because in terms of the specifics to do with this case, of the ramifications, it says, potentially for patients currently detained under the Mental Health Act, if they may only achieve discharge through acceptance of stringent restrictions and conditions, which may amount to a deprivation of liberty in the community, but also in circumstances, as Ms Richards has just outlined, where the tribunal, hearing their appeal against such a CTO, would not have the power to review those stringent restrictions. And in addition, our evidence will show that the tribunal rates of discharge are in fact quite low for this group of patients. So in its written submissions, Mind does make 5 core points, which, as I say, I hope in the time available, just a headline probably, some of them by way of summary, with some limited expansion along the way. I don't need to dwell, for example, the first point, paragraphs 8 to 17, Mind has addressed the intention and the purpose of CTOs by making 2 points in relation to the fact that the statute does not, and CTOs were never intended to deprive a patient of liberty in the community at the time that the Act was passed, and Mind agrees with the appellant's submissions on that point. And I don't propose to add anything more, which is written in our written case. The second point that Mind highlights is that at the time, and Mind's view, is that the CTOs as drafted are only suitable for a small group of revolving door patients. And these are patients with enduring mental illness such as schizophrenia, patients who demonstrate a clear pattern of response to medication, patients with a known history of non-compliance with their medication, associated with a rapid deterioration in their mental disorder and high risks to themselves and to others. For such patients, a swift response by recall to hospital for further treatment may well be appropriate. And once they are treated in hospital so that they are sufficiently well and safe to discharge, we would say they are highly unlikely to need a deprivation of liberty in the community. Our second main point in relation to our submissions is at paragraphs 18 to 30. And it basically is the point that Mind makes that subsequent to its enactment, the impact and use of CTOs has escalated. There is now an overuse, we would say, of CTOs, which doesn't fit with the way the statute has been drafted. So Mind has had concerns which arise from what it says was an underestimate of the use of CTOs at the time the Act was passed, so that it has highlighted that its concerns of overuse of CTOs go now beyond the revolving door patient and is also compounded, we would say, by the low rates of discharge, so that you've got a high rate of patients going in to hospital and being discharged in a CTO, and a low rate of discharge from a CTO, given the poor powers of the tribunal, which has been described in other places, and we have described also as a lobster pot effect, quick to go in, but slow to come out. The figures that Mind relies on for that point are presented at paragraphs 22 and 26 of our written case. And we say that these bear out these concerns. And in relation to the overuse of CTOs, it's quite useful to look at the chronology since introduction. It's been 10 years, more or less, since the introduction of CTOs. And in those years, we say, CTOs are being used for a wider group of patients, such as PJ, with learning disability and autism associated with risky behaviour. And they're being used to support the government's community-based mental health services, and they're being used to in changed circumstances since 2007, reflecting reduced facilities and services for mental health patients, which is widely written about. The consequence, we say, is that there is this additional category of patients like PJ now being shoehorned into a set of provisions that we say, and we agree, are not fit for their purpose because of the lack of adequate safeguards for deprivations of liberty. By way of some explanation, the chronology might also demonstrate, for example, that PJ was, we know, discharged on CTO in September 2011. It was the same year in which, and it's probably entirely coincidental, we're not drawing any cause and effect directly here, maybe entirely coincidental. The wider context was that in June 2011, the well-known Winterbourne View Hospital scandal broke, and that was the catalyst for the laudable strategy of introducing a community arrangements for learning disabled patients. What we say is that even in 2007, learning disabled patients who were cared for in the community were unlikely to have been considered or identified as being deprived of their liberty, because this was pre-Cheshire West. So we look at the chronology. Cheshire West was decided by this court in 2014. So at the time in 27, it was unlikely that such a patient would have been identified as being under a deprivation of liberty. And as my learned friend Ms. Richards has also identified, 2007 is when there were specific statutory provisions made for deprivation of liberty in the community by the Mental Capacity Act. So, I think moving on, Mind's concerns on this point are summarised at paragraph 30 of our written case, and I would invite the court to read that, if it will. In summary, I think it is worth saying that Mind's submission is that the Court of Appeal has created a powerful clinical tool, it would appear, but one which may exacerbate the overuse of CTOs and encourage something that Mind is very much against, which is unchecked preventative detention in the community, where tribunal powers are narrow and rates of discharge are low. The third main point is that at paragraphs 46 to 59 of our written case, and in highlight, it concerns the disparity in the level of safeguards for a deprivation of liberty available to a patient detained in a care home under a CTO in the community, like PJ, and one detained in the same care home under the same restrictions under the Mental Capacity Act. And the disparity here, which we have characterised as an Article 14 taken with an Article 5 discrimination, is that a Mental Capacity Act patient will have available to him or her the Court of Protection and the review of that deprivation of liberty that is available under the powers of the Court of Protection. And we've set out all those powers in detail in our submissions in our written case. But I really hope it's self-explanatory from that. But the significant detriment to a CTO patient under conditions of a DOL under the Mental Health Act creates an anomaly, because the Mental Capacity Act patient has access to to a court of protection that can examine the conditions of the DOL, giving rise to deprivation of liberty, which of course the Mental Health Tribunal in this context, as you have heard, cannot. The fourth main point, I think I will simply headline at paragraphs 31 to 33, are the alternatives available under, for example, Section 17, which Ms. Richards has also already referred to, but also that what Mind says is that this does not impact, the fact that a CTO cannot deprive a person or a patient of their liberty in the community doesn't deprive a responsible clinician of his or her clinical autonomy. There are a number of flexible and useful clinical tools which can be used for this specific purpose, such as Section 17. And you've already heard that Section 17.3 permits a responsible clinician to effectively authorise the detention of a patient in the community while they're being tested out for their suitability for discharge, either absolutely or under a CTO. And so those alternatives are on paragraph 32 of our written case. So the fifth and our last main point is set out at paragraphs 34 to 45 at MS 137. And it concerns this point about coercion and lesser restrictions. And it derives from Mind's grave concerns over the legality and practicality of the Court of Appeal's notion that a DOL, a deprivation of liberty under a CTO, is intended to be a lesser restriction on freedom of movement than treatment in hospital. I don't intend to take the court to the paragraph, but it's paragraph 53 in the Court of Appeal's judgment, which is in the appendix at MS 200 that it is set out. So the basic point that Mind would make is that the threat of recall in itself exerts significant pressure on a patient to cooperate, such that if a deprivation of liberty is also imposed, or conditions are also imposed, and I'm talking here about those discretionary conditions imposed by responsible clinicians under 17B, judging lesser restriction is likely to be difficult and impractical. How does one assess by what margin restrictions must be less than in hospital in order for a deprivation of liberty to be lawful in the community under a CTO? Is a deprivation of liberty under a CTO inevitably less restrictive than one in hospital? And my learned friend, Ms. Richards, has already eloquently addressed that, and we agree with her points that it is not necessarily so. So Mind has addressed this in three ways in its submissions. The first is that a CTO without or with conditions is coercive, and the threat of recall, as I've already said, places undue pressure on a patient to cooperate. Now, the evidence that we've filed is illustrative of this point, and I might ask the court to turn that up. It's at MS 146 in the core volume. It's the evidence of Alison Cobb, and she sets out there at paragraph 8 a summary of the evidence that has been filed. So at paragraph 8, she says, people had very negative experiences of CTOs, and the regime was experienced as coercive and intrusive. And if I could also ask the court then to go to the exhibit that she adds to her evidence, referred to at paragraph 9. It's a report of a workshop held in May of 2018 for the purposes of the Mental Health Act review that's just about to report. And it sets out at MS 154 what those participants had to say about CTOs. It also annexes at MS 171 the actual record of what was said by the patients. And it may be more useful to go to that, if I might do it that way, at page 171. Annex 4, community treatment orders. Patients said they felt cornered, they felt stuck between a rock and a hard place. It allowed them, on a positive note, to stay out of hospital, but based on threat. They felt like being tagged. It was stigmatizing. And then, a little further down, hospital against a CTO was only a little better than being in hospital. It was intrusive, having to take medication in front of your staff in your own home. It was disempowering. So there's very little, certainly from that response, that is positive for these patients about CTOs. And the second point Mind makes about CTOs builds on a point that Ms. Richards has already made, which is that when there is a deprivation of liberty, the difference in restrictions between hospital and the community can be thin. And she's already referred to the particularly intense limitations on PJ as he was under a CTO when he was in hospital and prior to the discharge of the CTO, as being evidence of that. And we would agree. The facts of CTO, which in fact also are at MS 57 in the Statement of Facts and Issues, show that the restrictions on him were really intense. And we would say hard to differentiate, not simply from a low secure unit, but from a medium secure unit, given the intensity he experienced. We would also refer to the case of Ashingdane, which the court has had knows well, considered the application of Article 5 in the context of a high secure detention at Broadmoor Hospital and then in lesser security in a hospital called Oakwood. And without turning it up, if I could refer the court to paragraph 24, which is at tab 34, MS 1624, where the court said that ordinary hospitals house both voluntary and detained patients, and no appreciable distinction is made in their regimes. So mine submits that it is therefore the existence of the Mental Health Act detention, the section itself in that situation, that creates the difference in hospital between voluntary and detained patients, even under lesser restrictions as in Ashingdale. So you can be under the same regime in the same hospital. If you have a section imposed, it's almost obvious. You are detained, but you could be a voluntary patient in the same circumstances. And that is illustrative, we say, or can be illustrative of a situation in the community where a patient is under the threat of recall, a statutory threat of recall, it's hanging over your head, that this level of coercion, it cannot be underestimated. It cannot be underestimated from the patient's subjective point of view, but equally because it has potential legal implications. And one of those is that the threat of recall is also a factor, we say, that can be taken cumulatively with other factors, such as escorted community leave or access, to tip into a deprivation of liberty.
I'm afraid you've run out of time.
I'm grateful, my lady, and I frankly have very closely come to the end of my submissions. If I might just ask the court kindly to read our conclusions at paragraph 60, which comes to that, and also I think that'll be sufficient. I'm very grateful indeed. Thank you.
Thank you very much indeed. Well, we'll adjourn now and look forward to hearing from Mr. Gordon at 2:00.